Do you have confidence in the Supreme Court? I mean, they've yet to rule on this immunity thing, all this thing about Alito and the flags and Clarence Thomas and his wife. I mean, do you have confidence in the Supreme Court?
No, I think they've gone rogue. It's most unfortunate. But it's unfortunate further to see what the other justice, what happened to the Chief Justice?
The rule is that they've gone rogue whenever they do something that Democrats dislike, whenever they come to a decision that Democrats oppose. That's obviously Congresswoman Nancy Pelosi. If you are listening to the radio program Coast to Coast, or if you're watching the simulcast, you got to see her say it to Anderson Cooper, which you can find Channel 347 DirecTV, find us on Rumble, X, YouTube, everywhere. So on this, and we had one of these, we had the headline about I was pulling this up, the student loan, huge issue. The student loan debacle that the Biden administration was trying to push over. Two federal courts blocking parts of this student loan giveaway. And as we discussed, one of really the tip of the spear on that in Missouri, Attorney General Andrew Bailey, who now joins us via Skype. Sir, always good to see you. This was good news. And I thought it was interesting, too, an Obama appointee in Missouri. Judge John Ross ruled that the Department of Education can't forgive loans under this program. Obviously, you were happy with this outcome.
Yeah, Dana, thanks for having me on. This is an important win for working Missouri families. At the end of the day, the Supreme Court in June of last year told President Biden that he had no legal or constitutional authority to redistribute $500 billion in debt owed because of these student loans. It harms Missouri because we have the Missouri Higher Education Loan Authority that is an apparatus of state government that is funded by our General Assembly. So it's going to cost Missouri taxpayers north of $45 million. And any working family or small business owner will tell you there's no such thing as debt cancellation. Somebody's paying it. That's why this lawsuit was so important to go back around and tell President Biden, Congress still hasn't passed any enabling legislation to allow you to do this. The Constitution still prohibits you from spending money absent congressional authorization. The rules still matter. And we're not going to let Joe Biden saddle working Missouri families with Ivy League debt.
Exactly. And I think working Missouri families, I think families that are young families trying to get started, middle-class families, poor families, rich families, the retirement family, people who are empty nesters and they're getting ready to retire, they've retired. I mean, they were all saddled with this. Because this seems to be one, and we're talking to Missouri Attorney General Andrew Bailey, this seems to be one of several decisions seemingly indicating this move in the judicial system away from this steroided out administrative state to make law where Congress or state legislatures have not. Is this a trend now? Is this enough decisions to say that it is?
Absolutely. West Virginia v. EPA reinvigorated the major questions doctrine a few years ago. And then our student loan case that was handed down in June of last year reiterated the major questions doctrine. It basically stands for the proposition that Congress doesn't hide an elephant in a mouse hole. If Congress intends to enact a program on this order of magnitude with enormous socioeconomic, cultural, political ramifications, Congress has to be explicit. The president can't latch onto vague references in statutes for programming or enabling rulemaking to then do something this big. And that precedent holds in this case. It's going to hold in other cases. So there's no sanction in the United States Constitution for an unelected bureaucratic fourth branch of government that consolidates rather than separates power. We know the Constitution is intended to protect us from the government, and that's why separation of powers is so important. The administrative state defies that principle, and thus we've got to use state attorneys general's office to fight back.
And this is one of the, this administrative state, this is one of the things that we're seeing this morning with the Surgeon General, Vivek Murthy, announcing this, 17-page action plan that he has. And it is, it's political advocacy. But he's talking about regulating things like the Second Amendment, firearm ownership, as though it's a health issue, I guess, as a way for them to have an in run around the laws that prohibit the federal government from establishing a national registry like he's calling for, things like that. Obviously, you've been watching that. What steps are you considering that you can share with us that you're considering using to protect Missourians, and maybe other AGs can follow suit against whatever Murthy and the Biden administration are set to unveil?
Well, I'm proud to live in a state where Article 1, Section 23 of the Missouri Constitution says that the state is obligated to use every resource available to protect Missourians' right to keep and bear arms. It's a sacred obligation that I take seriously. The Second Amendment's the one that makes all the other ones possible. We're not going to give up our God-given right to keep and bear arms, to protect ourselves from a tyrannical government, to defend our homes, our property, our loved ones. And a gun registry is just one step towards a gun grab that's been proven true time and time again in history. It is absolutely unconstitutional, and we're not going to let the administrative state start marching down that path. We'll file suit if we have to. We have multiple lawsuits pending right now against the Biden administration's attempt to ban ban pistol braces through the administrative rule without enabling legislation through Congress, and also the attempt to quote unquote close the gun show loophole. The founding fathers would have understood that individual to individual sales were essential to firearms commerce, and that something like that avoids a national registry. It's not a loophole if it's carved out in the law. So the president has no authority to pass a rule to end that. That's why we filed suit against it. And we'll keep fighting for our right to keep and bear arms.
That's a great point. I mean, it's carved out in the law. That's not a loophole. It's been thought of. It was mentioned. It's in the law. Talking to Missouri Attorney General Andrew Bailey. So I joke, but I really do think you do this. Like, you wake up every day and you're like, okay, well, I'm going to chew gum and I'm just going to sue commies. And so I'm all out of gum today. So he announced, you guys wait till I announce this tweet, because I'm not joking. You say you're filing suit against the state of New York for their attack on our democratic processes through the unconstitutional lawfare against the former president. This is a case, that New York case, I cannot wrap my head around. I am shocked that it's being taken seriously to use, what I guess at best maybe a misdemeanor, but it's expired beyond the statute of limitations, and try to attach it to some other mystery misdemeanor or whatever, so you could elevate it to a felony because nobody else wanted to do it. You can't touch them in the state of New York, so they're going to try to say it's, felonious activity, and that it's allowed to stand. But yet Hillary Clinton can get in trouble for working with Fusion GPS and actually gets in trouble for what Trump is accused of, but nothing happens to her. She's in New York. Talk to us about this, because I really wish that more AGs would use the power that they have to step up where we don't seem to have any kind of presence.
Yeah, the lawfare being committed against President Trump is nothing short of a direct attack on our democratic process. Missouri has a sovereign interest in participating in a national presidential election on equal footing and on equal terms with every other state. And we can't let a rogue prosecutor and collusive judiciary in the state of New York upend a presidential election. At the end of the day, President Trump is the chosen candidate for the Republican Party on behalf of delegates from the state of Missouri. And Missourians have a First Amendment right to hear from the president and a right to have access to the president in the heat of a campaign in one of the most consequential presidential elections in this nation's history. The normal judicial processes to adjudicate the rights of a criminal defendant who's been charged and convicted unlawfully, as in this case, are insufficient to redress the grievances of the voting public of the state of Missouri. That's why we're filing suit under Article 3, Section 2 of the United States Constitution. The Supreme Court has original jurisdiction over cases in conflicts and disputes between states. And right now, Missouri's got a big problem with New York.
I wanted to ask you, too, we're talking with Missouri Attorney General Andrew Bailey, because we got the debate Thursday, and part of this lawfare includes this gag order, that meaning that if he's on the debate stage and Joe Biden wants to bring up one or several of these cases that Trump is disallowed from speaking about, how is that not a First Amendment issue at that point? How is that fair?
Yeah, you're right. That is absolutely a First Amendment issue. And it's important. People often neglect the fact the First Amendment protects not only a speaker's right, so the president's right to speak as a presidential candidate, but it also protects listeners' rights to hear. And that's where Missouri and every other state becomes involved. How many individuals in the state of Missouri have voted for President Trump in the past two presidential elections? How many individuals went out and caucused for President Trump, myself included, most recently in our caucus here in the state of Missouri? And now we can't hear from our chosen candidate? No way. That violates our constitutional rights. There's a strong constitutional presumption against gag orders, and a gag order is intended to protect the defendant's right to a fair trial. Well, the trial's over, and if President Trump wants to waive that right, he should be allowed to do so. But that's why this suit is so important.
Do you think some of these cases, obviously, there's a road to go with them, but it seems to take forever, any or all at some point, especially the one in New York, because that seems to be completely uncharted territory, could that go before SCOTUS at some point?
Well, I think it has to. There are too many constitutional errors in the trial, in not only the charging document, but the gag order, the lack of jury unanimity during the deliberations and ultimate conviction. But what I'm concerned about is that not only was the prosecution replete with constitutional error, thus evidencing the fact that it was a politically motivated witch hunt, but the ambition was never to obtain a legally valid conviction. It was intended to take President Trump off the campaign trail, and they tethered him to a Manhattan courtroom for months at a time, and now there's going to be a sentencing. It's potentially going to send him to prison, or at least shock time in jail, or onerous conditions of house arrest and or community service. Missourians need to have access to a presidential candidate. He needs to be on the campaign trail. We've got to put a stop to it. Missouri has a sovereign interest in ensuring that President Trump is out campaigning and courting Missouri voters who have supported him in the past.
So that's why that audio soundbite Pelosi we played, that's why they want to go after SCOTUS. It feels like they're trying to stay steps ahead. They're anticipating that at some point that could happen. So let's go ahead and let's try to pack the court or undermine faith in these justices. That's their playbook.
They're so desperate to retain power, they're willing to destroy our legal institutions to achieve that objective. We've got to fight back and expose it for what it is.
Last quick question for you. Talking Missouri Attorney General Andrew Bailey, you're taking IBM to court over their DEI policies. This story, there's business after business. You're saying that it's a violation of the Missouri Human Rights Act. Tell me about this.
Corporate racism is still racism. It is illegal to make hiring and employment law decisions based on the color of people's skin and national origin. And yet you've got the CEO of IBM bragging about enforcing racist quotas and disadvantaging people based on the color of their skin or their ethnicity. It violates the Missouri Human Rights Act. We're the first state in the nation to take corporate America to task over this and harpoon this DEI whale.
I'm so glad that you're doing this. And I love that really, this is fighting for the people's coming down really to a lot of these attorney generals like you. And we're so glad that you're taking this fight, not just on behalf of Missourians. It's affecting, I'm a native Missourian. All my family's in Missouri. I'm in Texas now, but I still claim it. And it helps Texans too. So we're grateful for it. Thank you so much, sir. Good to see you.
Thank you, man. Appreciate you.
Of course.